Okay, so still waiting for the
Yeah, actually, this afternoon. Just put it down every time.
Yeah.
I guess it's like if you get in there and get, you know.
Different levels.
yeah, I moved apartments and
It feels like a.
yeah.
Right, right.
So that was
Oh.
still dealing with that,
Yeah.
obviously. Unpacking is
Moving is the worst.
yeah, and I still have to buy some stuff, furniture. Gotta drop a few racks. Huh?
I'm getting rid of some furniture if you need some furniture.
Oh, you're
Two,
going?
3
Yeah.
and 13.
Oh, nice.
Yeah.
Just take out a passport. They're on their way, email wise, of how long they're gonna take. They're on their way.
Do you have a dining table, small dining table? Okay, okay.
3 and 13.
Nice.
Yes.
Got it, or make a change.
Do you have a copy?
Yes.
Yeah, I got something.
Yeah.
You got it.
Yeah.
Okay.
Full fingers, it doesn't.
Is it?
You guys ready? You got an email yet, or we're waiting?
I haven't received the email yet.
Oh, and
Oh, I just.
You just came.
Yeah.
They're gonna keep covering.
yeah.
I've seen pictures.
All right, let's keep it together.
Yeah. Yeah.
Yeah.
I can't do it all. Like it'd be different if it wasn't today. Sorry, at 30.
Right.
Like,
Train ride.
Because you gotta.
Yeah.
just the last,
So it's a lot.
that one's highlighted.
Oh, yeah.
So, you wanna get started?
Yeah, I'm ready to go.
Well, before you start, I mean, could you tell me, are either of these, substantially different from the previous account?
I don't think, honestly, I don't think our 3 is substantively different.
Okay.
I think it's pretty much, I think we've probably passed something very close back and forth probably 4 times now. I think you guys have made some changes and some alterations in an attempt to speak to some of our issues, which we appreciate, but we just, in terms of our response, I don't think our response is substantively different than responses you've seen from us before. On 313, you guys had proposed so much new language, and I think some of it we actually did sort of take, and then some of it we said, we take this, but I'm not so sure this is where it goes. We didn't take most of it, obviously, as you can see by the scratch outs, but there were a couple of components that we think we can sort of take and deal with. So in that respect, it's substantively different.
Okay. Alright, okay, so I mean. I don't know if it's true, we're rehashing all the same points for this one, do you guys have any questions?
Agree.
Yeah.
No.
Alright. So you wanna go on to 13?
Yeah.
So this is also one where there's been so much changes, there's been a lot of changes to it back and forth, so if I skip something. It's not intentional. If you want to go back with a line number, I'm happy to sort of go back to that point as we're going through it. So, most of this, and again, I know we've had this conversation multiple times, and we're happy to sort of go through it again if you'd like. But the general position of the university is the fact that we are trying to align, not separate the way that we interpret a lot of these very critical definitions of some of the terminology in this article, and creating different standards for the different employee groups is just something that we are trying to, obviously, you can tell from our proposals, we're trying to avoid. So again, I appreciate that you had added a lot of more languages in 13.1, and we're just not interested in creating all the new components, because we believe that to the extent that you need them to be included, we believe that the ones that are appropriately covered legally are already inherent in the language we have, combined with university policy and regulation, as well as the state and federal law. And I know we had the conversation back and forth, but we are allowed and it's permitted that we bargain more. And while we'll acknowledge that it may be permissible, we're just not interested in making it any more complicated than it already is, because the topic is a very complicated topic. And again, the standard differential between the different groups is just not something we're interested in exploring.
What is the standard differential?
Well, so for just in a simple example, I won't even pick one, but if we, let's say we were going to add one title or 3 titles, specific classes called out in the version in yours that we then don't put in for the other employees, it then creates a situation in which there's an expectation that we're doing it differently. And our interest is in making sure that we not only apply the appropriate legal standard, but that we also apply it as equitably as possible across the entire, for all of our employees. We want all of our employees to be protected from discrimination.
Right, but the thing is, I mean, what we've said at the bargaining table is that we find that to be quite lacking. And we are employees that have bargaining rights, so we can, I mean, our objective is to increase our protections against discrimination.
Right.
And what you're saying is that, well, we want everyone to have the same, but what you have currently is not good enough from our perspective. So, I mean, yeah, go ahead. I won't.
No, that's fine. I mean, that's,
Yeah.
it's okay. I think while I acknowledge the perspective, what I don't think you'll be able to argue based on the language that we proposed and the other regulations and policies we have in place is that our proposal doesn't meet the standard expectation of what is legally required. So I just want to make it clear that, and I don't think you're saying that either, by the way. I don't think that's what you're saying.
Why would we? Because we're like the bargaining team, we're trying to talk about bargaining with you, and you're saying like, well, if this was a legal setting, you'd be covered by the law, this is a bargaining setting. And like the idea of like, we're not interested in this, it's, you're using that phrase so frequently that instead of it being about like a change we made to a specific article, now it's like, we want to bargain to get more protections, and now you're just not interested in bargaining protections with us and deferring to the law. So it's not like, I'm not interested in the specific thing you proposed to us. It's like, I just want the law to be the only thing that matters here.
Okay.
Do you see how that's like a huge difference between sometimes when you're like, we're not interested in, for example, providing like a parking spot or something. Like, okay, that was an article, that was like a specific proposal, but like, we're hoping for some like proposals where you're like, we would rather have this level of protection, you would rather have this level, what if we meet halfway or something, you know what I mean?
Yeah, I see what you're saying, Jacob. I guess the point is that I don't know how to say it other than interest, because what I'm here to do is to represent the university's interest writ large. I mean, that is overall the comprehensive perspective after talking to all the people that we talked to in terms of the stakeholders we represent, management. we're not interested. I don't know. I'm not trying to couch it in a way that you find demeaning or condescending. That's not my intention. I'm just saying that based on our analyzing your proposal, we don't have an interest in agreeing to that proposal. I don't mean it to be demeaning or insulting or off-putting. I mean, that's not my intention, so I apologize if that's the way it came off. I mean, I'm not trying to just use the same repeated language to be obnoxious. That's not my intention.
It's more about how that language has broadened over time, from like not interested in a particular proposal that was like specific thing or whatever, to like not interested in having any protections of discrimination over and above what you already get by virtue of being a Florida citizen.
Okay, so I think that's fair. So here's what I would say. I would say that when we, and this is maybe more about my style personally in terms of how I do this, there's a different standard for the types of language that's bargained. If it's new provisions and new language that doesn't currently exist in the contract, you know, there has to be a standard of us to have a joint interest or a mutual interest in agreeing to it. If it's a piece of current language that we've already previously agreed to, that's a different standard of whether or not we're going to continue doing it. In other words, if we want to change a piece of current language, or if you want to change a piece of current language, that's, you know, sort of the burden is on you to convince the other. And again, I'm just talking sort of in a general sense of my personal opinion, because CCL tends to, that's what we previously sort of agreed to. So when you have entire swaths of new language, and this wasn't like a word or two, I mean, these are huge provisions with significant, intense legal ramifications for the way that you've done this. Again, it's for us, it's not a small minor change. I mean, it is a huge, quite frankly, can be a very litigious component of the contract. So all of that went into our analysis of whether or not we're interested in expanding what's written. Again, our intention is not in any way, shape, or form to infringe upon the guaranteed rights of our employees or Florida citizens, nor is it to shirk our responsibility as an employer, but rather, again, we just don't feel that these expansions are necessary for us to ward against discrimination. We just don't feel it. We just don't feel it is.
So, so would you say that if someone is being discriminated on any of these things that you crossed out, that the university would consider that to be an acceptable type of discrimination?
No, I'm not gonna get into that hypothetical. What I'm gonna tell you is the fact that we don't believe that what you have listed here is something we're interested in putting in your contract. A hypothetical case without a fact pattern to say if this hypothetical thing would or wouldn't be discrimination. I mean, I'm not gonna.
Why not? I mean, that easily could happen.
Because discrimination cases are very complicated. Like, you need to know all the information about a case before you say, well, if I make an accusation of this, would it be discrimination?
Okay, so would you say if someone was being discriminated on the basis of race, would that concern the university in terms of the discrimination?
That's language that.
Right, so that's what I'm saying. So with race, you're willing to say categorically, yes, of course, that's discrimination. And for all these other things that we've listed here, you're just saying, well, you're avoiding the question of like, well, we wouldn't consider that discrimination, but the fact is you wouldn't, because it's not in common.
So in terms of the individual protected classes that you're listing, the simplest way I can say it is that we are not interested in adding all the additional protected classes that you are listing, but that doesn't mean the negative that just because someone is claiming one of those particular classes necessarily, that they don't have the ability to bring a claim or something like that. If you're not prohibited from filing a grievance or filing a claim.
But there'd be nothing that they could point to in the contract to say that those.
So here's what I would say to that, and this kind of gets back to the whole issue of the article in general.
Right.
Most people who I think feel that they are suffering discrimination, the first thing they're going to go to as an employee is not necessarily going to be the CBA. They're going to go to federal law and the regulations of the university. Like, they could also bring a grievance, but quite frankly, of the things available to you, and I'm going to defer to Olivia about this, because in terms of the hierarchy, sort of the big mechanisms that you have access to if you believe you've suffered discrimination is not going to be the internal grievance process. You're probably going to file with another group. I mean, you could notify us through the grievance process, but you're probably going to be filing a complaint in some other form or fashion.
Okay, and I just want to say another point about essentially you saying, I mean, I don't really buy what you're saying in terms of like, well, we don't want to have different rules for different employee groups. The fact is, you already have different rules.
We do, yeah, absolutely.
We have bargaining rights, and the whole point of that
Sure.
is that we're getting different rules, right?
Yes.
And so if other employee groups had that, they would do the same thing for themselves. So it's just not it's not, frankly, it's not an argument that I'm interested in hearing. I think you're gonna have to tell us exactly why, these categories are categories that the university doesn't consider to be, important protected classes when it comes to
Yeah,
discrimination.
except I don't, and I can just tell you what I've told you before, which is. We don't believe that they are necessary and we're not interested in them. I don't have to opine individually on any particular component. I'm not required to do that.
No, whereas I can't require you to do anything. But I mean, if you wanna have a productive bargaining session, we have to understand why is it these, I mean, beyond that, you just don't want you don't want the same rules. I mean, that's silly because that's what the whole point of this process is. We're getting, different types of rules for ourselves through the bargaining process.
All right, well,
Can I ask you
Yeah, go ahead.
why you think that these things that you've added aren't already covered by the current contract language?
Well, where are they listed elsewhere?
Where it says, or any other category protected by applicable federal or state law?
Are all of those protected by federal and state law?
Well, you can tell me if they're not.
You
Do you wanna
struck them
change the
because you
language?
said they weren't.
Do you wanna change the language? It's not our burden to explain why you wanna change, why you don't wanna change it. If we have a catch-all that says it's protected by federal or state law.
Well, I mean, we're listing those things in case that they're not, and we still think that those are.
Okay, so
important
that's,
categories.
then it's your burden to explain why we need to add things that aren't protected by federal or state law. And if you can identify, maybe when you come back, you can identify those and we can consider it.
Well, on your point, we've also added an additional amendment to the catch-all where we say any other factor with the admin question will not interfere with job performance and with the employees otherwise qualified, which could be a catch-all that would replace a lot of these categories and I think make us feel very protected. That was also crossed out.
Yeah.
So if the intent was to have a very good catch-all, why was that sentence also crossed out in that intent?
Because that's not the catch-all we were interested in.
Right, so you're
So-
saying the catch-all, if it catches everything, then what's the problem?
And also, I mean, so what you are interested in is having some kind of factor which are not related to job performance that people can be discriminated.
No,
no, that's not what.
So then why cross that out?
Because the way that it's written
Yeah.
is that it's written in the negative and that anything that we can't objectively prove meets is by default, therefore, the way I read that is what you're trying to say is anything that we can't specifically link is by default discriminatory. And we don't agree with that.
Okay, so what are the other types of instances where someone is being discriminated against and it's not due to their job performance?
No, I think it's not just because something isn't specifically listed doesn't mean it is default
So
discrimination.
what else could it be?
It could be job performance. It could be the fact that we don't want to non-renew someone. It could be the fact that we want to put them on a performance plan. It could be all of those things. We don't want to have to go through the standard every time we take some sort of action that to prove that it wasn't discriminatory. We don't want to take that burden on to prove that it's absent of all these other factors. And we therefore have a standard that we have to prove that it's not definitively any of these reasons. That doesn't mean that just because we're doing it, it is therefore discriminatory. It's sort of the yin and yang of the way that it's structured, at least the way we've.
Okay, wait, I think we should move on.
I just wanted to say a very quick thing, which is in a lot of cases, we use language from the faculty contract, and that has been cut. So you claim that we just want equal language across all the things, so it's not complicated. But you can do that by gutting all things that aren't already covered by a lawmaking body that has nothing to do with you. Or you could do that by putting the same level of discrimination protection, which is over and above what the law body decided to give to every Florida citizen. And you're choosing the former, not the latter. You're choosing to try to bring the discrimination protections down
To the
on the
lowest
whole,
possible.
to the lowest legal limit. Any less protection whatsoever would be illegal. And we want to put everyone there. Instead of we want to raise everyone up to the level of protection that one of the other units or whatever our unit or whatever. There's a decision being made there.
I believe most of this language was taken from other graduating contracts, so it's, what the.
Yeah,
the
some of
legal
it was from
counsel,
like
other
UMass,
universities.
it was like UMass,
I
Connecticut.
did some of it.
Yes, there was quite a
There
few
was stuff
universities,
from-
and then
Yeah,
I
some of
think,
this was.
yeah.
There was from factory, yeah, I'm not saying all of it.
Yeah.
The point I'm trying to make though is that you could level the playing field in different ways, and your team has this variety, and where you wanna level it is at the very lowest legal minimum you possibly could as an institution, and if you did any less discrimination protection, it would be illegal for you as an institution. That's what you're saying, but you're presenting it as like, oh, it would be more convenient if it was all the same. But it's more than just, it would be convenient for being the same. It's, we want no extra.
I don't agree that our position is that we were trying to gut every single component of discriminatory protection other than what's legally required. I don't agree with that characterization.
What does
All
it
right,
mean
yeah,
then
we
to
need to
say,
move on.
okay?
Can I ask a quick question?
Yeah,
So we inserted like an attempt at defining discrimination.
Mhm.
But what you were saying earlier with like, we would need to prove everything, like a non-renewal or something was not discrimination. The beginning of this like C as it's currently written says like, the university shall not discriminate against or harass based on any of these things. So I'm just wondering how would that operationalize? Because if you non-renew someone, they wouldn't necessarily default to discrimination, right? Because it's specifically says, you know, you shall not discriminate
Correct.
against.
Correct, in the current language, you're
Yeah.
talking about the current contract.
Yeah, and so I'm
Yes.
just wondering, like, could you justify that explanation that you just gave us? Because I don't see how that would fit in actuality.
Yeah, so I think the thing is, if you look in line 29 of your last proposal, which says, or any other factor where the item in question will not interfere with job performance and where the employee is otherwise qualified. I think we're not interested in adding that to what's already in there.
Well, how does that,
Yeah.
so how does that, could you just walk us through how that makes how that language makes it so you always have to prove every action is not
Yeah.
because of discrimination?
Sure,
I just
because-
don't see the
Yeah, so
why that,
so in the current language, we say we're not gonna do it.
right,
You then have to, I mean, the agreement would have to then prove that we did it.
okay.
Whereas in this case, the way that I read 29 is that you basically get to say, it's not exactly as the previous one you brought, which is basically anything that isn't specifically linked. This isn't the same version that you had brought previously. You had another version where the catch-all was even more sort of tried. This one's less, it's less than so. But it says, or any other factor where the item in question will not interfere with job performance and where the employee is otherwise qualified. So then it becomes on us, because if it isn't that, the assumption based on this language is that it is discrimination. Whereas the way it's currently written, it just says we shall not discriminate, and you would have to prove that we discriminated.
Austin, was that language in other contracts?
Yeah, this is taken from the contract, I can't remember the exact contract it was taken from. But-
So, I mean, I think clearly, I mean, if that language is in other contracts, I mean, I highly doubt it would be being applied in the specific way that you were saying, which is that in like a non-renewal, which cannot be associated with discrimination or harassment, and then,
Yeah, because it starts with,
Yeah.
it needs to be discrimination or harassment,
yeah.
Mhm.
right? So do you see where, like, my default is not that it's anything. My default is that it's harassment or discrimination. So I don't understand how this catch-all contradicts the beginning of this.
Yeah, because
Can I ask
Section.
you all to explain what that even means? I'm not trying to be, but what is this? So what this is a list of is the types of characteristics a person can have.
Mhm.
And that you're not gonna be treated differently because of that characteristic.
Right.
So what is the characteristic that's being covered by any other factor where the items, I don't know what the item is, in question will not interfere with job performance and where the employee is otherwise qualified? Can you give me an example of what that characteristic is?
Well, that is, I mean, it's a catch-all for things, because we have this list, we recognize the fact that there may be things that we're not covering in this list, you can't have an all exhaustive list, and we want to make language that will last for years and years. And so that covers if there becomes a very large area that like we're not covering in this. I mean, if the university comes out and they're like, we are not gonna hire anyone with blue eyes, that sort of thing, and eye color is not covered in this, then like, that would be a catch-all we would count in that. category.
So the item would be
Like the
one of
characteristic.
one of these categories.
Yeah.
That is not
Characteristic
here.
was
One of the, yeah.
Okay.
So in his example, the item in that case would be the blue, not hiring blue eyes because of the blue eyes.
And I mean, based on all of the stricken things like pregnancy status, wouldn't be covered by race, creed, color, religion, like,
It's covered by.
I mean, essentially,
Yes.
it might be, I
Pregnancy
think, a
status.
slightly clumsy way of wording it. I mean,
yeah.
another way of
Yeah.
saying it, or any other category that doesn't interfere
Yeah.
with job.
But then like, how does the university, how are we on notice of like what all those other categories are?
Well, like, this would be an obvious one, right? Like you're being discriminated based on your eye color.
Right,
It's
which we're
not
obviously
being,
not going to do, but
It's
like,
right, yeah.
but what's like like a realistic example?
well, that's the whole point. I mean, if we could think of it right now, we would have just listed it directly.
But the test
But if
is
it's not
right there,
happening, then why do we
does
need to
not
get there?
interfere with job performance.
Yeah.
Your
That's the whole
policy
point.
shouldn't be taking into consideration characteristics that do not interfere with job performance when discriminating like the semantic,
But like, is a
Making
characteristic your work ethic?
that would.
That would be part
interfere
of your
with
job.
Right, but so that's what I'm saying, like, it becomes a really slippery slope of defining what these other unspecified characteristics
No,
are.
it doesn't, because that one's directly related to your job, like, your work ethic is like.
But
how
yeah, I
much
think
you have to work.
most of the other things are covered by categories of things that are already protected. So I'm just looking for something that's a little bit more that I think it's so like, I didn't even understand what that meant. Now I understand what you mean by, because I think Patrick didn't understand, which is why but I think that you were interpreting it differently than
Right.
they were intending that.
Right.
And now that I understand what you're saying, I still don't agree with it, but I also don't think that this captures what it was that you were just explaining.
Mhm. Okay, we should move on.
Yes,
Yeah.
agreed.
All right, moving down to, line 4413-2. So again, I think you've kind of heard me say before in slightly different language that we're not interested in creating an opportunity to provide reports to GAU for GAU that GAU designs. You know, we do have an obligation to share all kinds of information that's available, and all types of statistics and reporting that we have to do that are already available. And I guess before we commit to creating additional reports, we're gonna need to know more about what it is you're actually interested in. Like, what is the goal? Because creating a responsibility of us to treat you as a report receiver on our behalf, it's just not something we're really interested in doing. Especially considering the amount of information and data that we already have to compile and share with the public. Like, I'm just not sure what. Again, we're not gonna create new reports for you all based on the amount of stuff that we already share. Now, part of that is based.
Sorry, I just missed what you were saying. So if we would like you to create a separate report, what are the things that?
He wants to know the goal, but
Yeah,
again,
like-
the line number 44, it says right there, equal opportunity documentation.
No, okay, no, let him finish. Let him-
So I guess what I'm saying is we already have to do this to other agencies at the federal level. Like, we already have to give these to bodies which are specifically responsible for observing and auditing our hiring and employment practices. I'm not so sure what this is going to accomplish it's gonna create a bunch more responsibility for us to give them to you. And I think we're gonna wind up in this type of a situation where we're now gonna have to sort of argue about whether or not they mean anything. I guess that it would be different if, I realize you're saying you don't think the protections are significant. I'm not gonna take that away. That appears to be your position, and I respect and I've heard it. What is it that you are worried is happening that you need all of this reporting for?
The same reason that the federal institutions require you to give documentation to make sure you're meeting federal law.
Right.
If you make our CBA do nothing over and above federal law, then yes, what you're saying makes sense. I take that up with them, it's their law, I report to them, they make sure I'm following it. If the CBA has any more protections than the law, then they're not checking whether you meet those extra protections that have nothing to do with them.
So
Implicit in all of this is that you're not entertaining, providing any discrimination protection over and above what it would be illegal for you to not do.
But you're not asking for information that's over and above what but like, you're not asking for, you're asking for race, gender, international status.
Yeah, I don't know.
So that's not what, that's
And also, like,
already
not
covered by
sure
our.
how
current
they would have, information, like for all those other categories,
Yeah,
Yeah, well, I mean, it's all self-reported anyway. I mean, you want us to start, I mean, if we were to take them together, what you're saying, Jacob, is you want us to actually ask people to disclose their political opinion and affiliations so we can then report it to GAU?
No.
I can't imagine that's what your intention is.
Yeah.
No.
Because we don't want to collect that information for you all. And frankly, the race, I mean, a lot of that other information is self-reported anyway. We go based on what you all tell us.
Mhm.
And I mean, employees in general, not just GAU, but
No, we discussed the shortcomings of that kind of data last time, and we're aware.
okay.
Yeah.
So I guess if we're willing to move down to line 66 then with respect to 13.3. We feel that we would like to take, if you look down at line 74, acknowledging that it's a combination of both sexual harassment and sexual misconduct. And then giving the definition of sexual misconduct, which is consistent with the regulation, which you can find down from lines 87 to 92. You know, expanding the definition in the contract to meet that, we are acknowledging we don't have a problem with that, we're okay with that. But going through all the other definitions of the types of sexual harassment and then putting that in the contract and then be bargained, as well as a specific predetermined disciplinary procedure for it, we're not interested in going through all of having a completely separate disciplinary procedure just for discrimination.
Austin, do you wanna comment on what are the distinctions of, I mean, how do these disciplinary procedures, how are they different?
well, I mean, to go back a little bit to line 99, where I go through these different types of sexual harassment. I mean, a lot of that is directly taken from, again, the faculty contract.
So I acknowledge that.
Yeah, and if the intent is to match up these.
And those are
definitions,
pretty
then-
like standard,
Yeah,
both of those.
Yeah, it's not, but that's actually already covered by the language that we have in here. So quid pro quo harassment, which is actually not the legal term, is actually covered by,
Is it what term, sorry?
it's not a term that the courts use anymore.
Okay.
And that is actually covered by, the numbers, okay, or so I'll use the line numbers, 78 through 79, that's quid pro quo. Submission to a term or condition, submission to harassment as a term or condition of an individual employment, that's quid pro quo harassment. Hostile environment harassment is lines 84 through 86. So those are already covered by the current language. And actually, I just think it's in people's better interest to have a broader definition than I found sometimes when you have kind of narrow definitions or when you give lists of conduct sometimes. It makes it, could be sometimes be harder to, like, people will be like, well, it's only harassment if I do these things that are listed here, even though I know we say it's not limited to those things.
Sure.
I find it sometimes better to have a broader definition, that way you're capturing more conduct than the things that we're listing out. So I think it's beneficial for the GAs to not have all these kind of specifically delineated.
But what about cases in which it's not like the employment itself, but like, let's say your PI says, you know, if you do this, then I can put you as a co-author on this like paper or this grant or.
Right, so that's not covered by this contract because this is an employment contract. That would be covered by Title IX. Because that interferes with your academic program as a student. So if you have a harassment issue,
But it is work, like our publications are part of our work, it's our part of
100%.
research.
well, then it would be covered by this.
Right,
But
well,
is
if
it
it was in
covered?
there, it's not in
But that's
here.
clearly an example of quid pro quo. You're saying your PI is offering you, if you do a sexual favor, they're gonna make you a co-author. on a
It's an
paper.
example of quid pro quo, because it's listed quid pro quo harassment, and then advancement is listed. Here, it says a condition of an individual's employment.
Okay, so how is what you're saying not individuals' employment?
Because publishing is not a condition of employment, it's something that you do as part of your work and it's, you know what I mean? It's like
Yes.
a part of your work, but it's not like your
It's not whether or not
job.
You could research a lot and never publish anything.
Right, the
really.
way it's related to our employment is we can have a work environment that doesn't have sexual harassment in it as a condition of our employment by bargaining with you for that protection. It doesn't mean like,
No, I think what you're saying is covered by this. If you're telling me that if you came to me and you told me, not me, or you came to Robert's office and you said, you know, he's telling me if I don't do X, Y, Z with him, he's gonna remove me as an author from this paper, and that's part of my employment as a GA, that would fall within. That would be potentially considered, that would fall within this language of line 78, 79. And if it wasn't as part of your employment, but instead as part of your student status, then that would be covered by Title IX, which covers all student side issues. This isn't meant to exclude, this would not exclude that. The example you're giving would be covered by this if it was part of your employment.
So I'm sorry, so Title IX does not apply if it's part of your?
No, it does, it applies to both, but I misunderstood what she was saying. I thought she was saying it wasn't part of her employment, that it was part of her research as a student. Obviously, our contract doesn't cover what happens to you as a student,
Mhm.
but Title IX would, because Title IX covers
Right.
students and employees.
Right.
So I didn't want you to think there wasn't protection for you, it's just not, as students' side harassment, that's covered by Title IX. Because we can't cover your academic side in our contract.
I see what you're saying, but then there's also been cases where during bargaining, you have bargaining team says, yes, this thing is covered under this language, and then it turns out that, you know, we don't, like with the, what's the word?
the bereavement.
Bereavement, right, we just went through a case or two about that, so I think making language that it's explicit about the things that are considered to be maybe like conditions of employment or what is quid pro quo is better for us.
I think it's interesting that you're saying in this case, it's more important to have the more general definition and catch-all definition, and in the other case, we shouldn't have the catch-all definition. But
No, I said the catch-all, we're happy with the catch-all definition of, or any other characteristics that's covered by state or federal law, and
Yeah,
that's good.
Right, we won't break the law, we promise, but not like
we won't discriminate about
discriminate
any other
things that are
thing, yeah.
unrelated to job performance.
But okay, let's not get bogged down in that.
Yeah,
I mean, I was actually going to ask about, what is, going back to the procedure thing, right? If I'm not mistaken, it's been a while, sir. Like, the procedure that you wrote here was taken from one of the, like, IB contracts or something like
Yeah,
that.
and
it was like,
I had modified it to match as much as I could for the
Right.
UF, with the understanding that I could have made a couple of errors in how their process works. But the process is specifically designed to separate
And
what is
essentially-
currently covered under our contract and the bare minimum as required by law and by university policy. And there's additional clauses in how we would have those additional protections.
right,
So it was supposed to become a nice bridge of understanding between, are those cases where UF has avenues to, discuss these types of discrimination and harassment, then they're covered.
we don't contradict anything in university policy or Title IX regulation or any of that. Which was what you had raised previously, which is that, there's Title IX, there's university regulation, and there's what's in the CBA. Actually, like, the whole procedure is supposed to be, well, you have access to Title IX, you have access to the grievance process, you have access, you can go into more detail about that, Austin. I don't remember all the details. But it was supposed to be written in such a way that, you have what are what's available through existing laws and university regulations, and then you have other recourses, through categories that are protected specifically in the CBA, and maybe not in other places, and through that you have access to the grievance. Right?
Yeah, I mean, that's the pure intent there, right, is to make sure that while we were adding these additional clauses, we're also helping the university, you know, and helping define how you would navigate those courses as you're going through them. But I mean, the entire cross out, I mean, it matches the original intent of crossing out the additional protected classes anyway.
And the whole point of writing all that out is actually helps to clarify, well, which one do we go to, or what are the options for a person who is facing discrimination?
Right.
Because as it stands, it's just like, oh, well, university regulation, the law, people don't know what all those options are in that. So I think having that written out specifically is also very important in terms of just like
Tells you the steps,
having
tells you some of the protections you have in
Right.
terms of like being coerced into accepting a deal and things like that, and
Right.
now all of that has been crossed out as well.
One final note is use the term like, it's better to be broad, but this is broad. It says including but not limited to. You're mostly describing being vague or non-specific, which doesn't help us. And so if you are concerned about like what would be best for GNU, this is actually the broadest, and we agree with you that broad is better. But I don't think vague is better. I don't agree with that. And that's what we're trying to express.
I just feel like there's like 3 different conversations happening right now about 3 different parts, so I'm not sure which section you were talking, I feel like, were we talking about discipline, or are we talking about internal university processes, or are we still talking about the definition of sexual harassment?
I mean, the
Well,
common
at this
thread
point,
is
we're
that
talking
they've all
about
been
everything that's crossed
The
out.
common thread is that they've all been crossed out, but we're talking about the line number we're on, 95, and, or
Okay.
97 or 6 or whatever, including but not limited to, is the thing I was referencing as saying that's as broad as it gets. It's just more specific, so it's not.
So I get what she's saying, okay, like, one thing we're talking about is about the broadness of the language on that specific article. Another thing that I had just brought up was the disciplinary procedures, which is in the next page. But I had brought that up because you had also brought that up, Patrick, about, well, you're not interested in having different disciplinary procedures. It's not different, and what we're actually doing is outlining the ones that already exist and trying to make it clear that there are, you know, there are options and there are, different resources when you're facing discrimination.
Yeah, and I don't wanna move too far ahead, but right before the this process starts with disciplinary procedures, I do wanna make a note, starting on line 138, that's the bottom of the page, so it's really line 139.
Yeah.
We have this paragraph on bullying, which you also have completely removed, and that's a
Yes.
brand new definition. And now I would just like to hear, you know, an explanation to
Sure,
that.
so we already have a workplace violence policy that covers that. That makes it abundantly clear that the bullying is not gonna be covered, not tolerated.
Right,
It's
and we
already-
want
it's already
addition, we want that protection codified in our CBA as well, because policy is great, and we appreciate the university having those policies. You know, if the university decided removing that, we would have new recourse. We want protection against bullying as well, locked in for our graduate assistants.
Right, and I wasn't gonna go trying to get ahead of everyone here, but like, you know,
It was-
this is all part of like, I mean, you've crossed out all this language, which is going into specifics.
Yeah,
And that's, for me, that kind of all falls under the same
it
category, yeah.
does. We were talking about 13.3 and you introduced each of these components, disciplinary procedures. All of these were already talked about from a bird's eye view, and now we're digging down into the details.
And that is another driving point, is that what Austin said is that we, you know, if you, any changes you make to policy, that's not anything we control or we influence our CBA. So, you know, that's a big push. That's a big reason why we're trying to, you know, solidify all these protections in here, so we know that they're guaranteed at least, you know, until the next bargaining cycle.
Well, but they are, our ability to affect policy and regulation is hemmed in by the protections that we're working on in all the stuff at the tail end of the contract that has to do with, you know, we have to delay the implementation if it negatively impacts the CBA, if there's a conflict, or if we're legally required to do so. So it's not that you have no, I mean, you actually do have the ability to to impact that and influence it, specifically with respect to implementation.
Well, with implementation, sure,
Yeah.
but eventually then you would come to where we are now, bargaining for those protections, because in that case, you would, like in that situation, just to take it to the conclusion would be, well, obviously, we would just wait until the next bargaining cycle to talk or to discuss those changes, so we don't want those implemented now.
Right.
And then we would be right here.
Also, have we engaged that?
No.
No, we haven't made those, but
That's just
yeah.
language that has been proposed.
But it's under CCL, you still have a severability clause, like that exists in current, fine, even if we don't agree to something new, if we agree to the way it stands, we're still hemmed in, I mean, you have.
Right, but the point is that we would be where we are right now is bargaining.
No, I don't disagree with
Yeah.
that, I don't disagree with your point.
Can I ask a quick question?
Sure.
I was just wondering, like, with the additional, definitions and explanations that were included in here, are you against there being more thorough explanations of the rights that GAs already have, as long as it is specifically like referencing the university policy or the law that supports those rights? Like, is there a problem with there being more information in the contract to help our GAs know what their rights are?
So I think it's a good question, so, and I'll give you an example, so if you look back at line 87, that's specifically one of the things that we attempted to do. For clarity. But I will also tell you that I don't necessarily believe writ large, the contract is the place to expound upon all of those things that are otherwise covered in some other place. I mean, if we included everything in the contract that exists, that don't just pertain to you, but pertain to everyone, I mean, you would have to include so much more information. So it comes down to what is critical and what is something that we're gonna agree is something we were willing to put in there, because then subsequent to that, we have to bargain with you about it.
As a follow-up question, so with this specific article, what would you point to in this article that is not already covering everybody?
I'm sorry, ask your question again.
Like, what, within this article, we've been talking a lot about how most of the things within this article are already covered by federal or state law or university policy.
Mm-hmm.
What's in this article that is not that? And if so, you know, like your argument is, if we already have all of these policies, we don't need to be talking about them in this article, but if all this article is expounding on those exact policies.
Yeah, like in 13.3, can you point out instances where we've contradicted existing university policy?
13.3.
Not even contradicted, but added to.
13.3 as in like the G.
No, I mean, added to, I think, is legitimate.
Which question are we gonna answer?
Because
That is,
well, no, let's answer the which ones are in contradiction of current university policy.
In 13.3?
Yeah,
Okay, so specific contradictions, I will say it's different. It's different.
what do you mean?
Well, so for example, what you have listed in E,
Okay,
all of this information, I don't believe is listed in, I mean, I can do a search real quick. I don't believe it's not in the regulation. It's not like you took the regulation and copied it and then pasted it in your proposal. That's not what it is. It's not. So that's different.
E, the one you're accepting.
okay,
So
okay, fine,
No, no,
okay,
like-
okay, no, let's.
13.3.
Sorry, the
Let's-
numbering, the lettering, we can just use line numbers because
Okay.
the,
Yeah.
the numbers.
So starting in line 99,
Mhm.
that language is different.
Okay, let's go down the list then, okay? In terms of like the disciplinary procedures, what is contradicted there?
Well, you've got a different disciplinary procedure here than what you have in the discipline. I guess one of the things I would question about this, and I'm gonna answer your question is, are you writing 162 throughout? Is the intention, and I know Austin, I think you wrote it, are you worried about protecting the complainant, or are you talking about the employer's rights? Because I'm not gonna lie, this is written where I'm not really sure, like you talk about the rights of the respondent in here. That assumes, based on the fact that it's an employment contract, that the respondent is an employee that's also in your bargaining unit, but that's not explicitly stated.
It could be, yeah.
But your contract wouldn't be, I mean, it would be inappropriate for your contract to go beyond that instance to where you're talking about, what if the respondent is.
Okay, so we can add more specific language about that, if that's what the.
But what I'm saying is, I think that's gonna make it even worse.
Contract can govern
Yeah,
employees who aren't subject to the contract.
Right, so we can
Right,
clarify.
so we'll just clarify that it doesn't apply to them, yeah.
so you're gonna write a disciplinary procedure that only deals with instances when one GA is making a complaint against another GA.
It seems like every single time we talk about a thing, you're like displaying shock that a bargaining unit would have extra something provided by their like their CBA over and above what like everyone else in this entire institution
We're
gets.
trying to make this clear, it's not clear, and so we're trying to, we may have read this and not understood your intention because the language is not clear, and this is the type of language and article that needs to be crystal clear, because these are the types of things that if people will say, you know, if someone's being accused of harassment or discrimination, if one of these things didn't go right, then it's just, this is where we have to be very clear about what our intention is, what the language means, because it is very procedural. These are the types of things that are grieved. These are the types of things that end up in lawsuits. So if something's not clear, we're trying to clarify it.
Understood, but you're just striking the entire.
Yeah, you're not
thing.
asking to clarify anything.
And what Patrick just would express like surprise at is that the disciplinary procedure for people in our bargaining unit might be different than the disciplinary procedure or have like an extra component or whatever
No,
from somebody in a other unit.
so I was attempting to answer the question of where it's not consistent, because that's how it started
Yeah,
this
let's,
entire line of
let's stick with
discussion.
that, let's stick with that.
So what I'm saying is, it would not be consistent for your contract to contemplate the rights or responsibilities of someone who's not within your employment bargaining
Right.
unit.
And so if we
So-
clarified we weren't doing that,
Right.
then what would your issue be?
So what I'm saying is, I think that's gonna exacerbate the problem, because now you're gonna have a very finely tuned thing that only deals with situations in which both the respondent and the grievant are both within, yeah,
No.
absolutely.
No,
No,
Yeah.
the
I mean, if
respondent-
either the respondent or the,
Yeah.
yeah.
If that's the case, then you can't, I don't believe it would be appropriate for your contract to contemplate what the rights or responsibilities of somebody would be if they're not covered by the contract.
That's
But
How is that insane?
We are-
If it's an
we are-
employment contract with employees.
because
We're
sexual
pointing to Title IX
harassment
anyways.
is a work condition thing that our employees do not need to endure. You don't say like, oh, CBA can only protect you from sexual harassment where they're both in.
No, I 100% agree, that's not what I said.
You're covered by Title IX, even if this is not in the
I don't know, it's
CBA.
not the CBA, I'm talking
No,
about.
okay, I think I misunderstood what you said. I thought you were saying if it's not in here, then GAs are subject to harassment. That's not the case.
CBAs can give us sexual harassment protections over and above the minimum legal limit. And when that is the case, that form of sexual harassment that we do not have to endure because we bargained to like have protection against it. We don't have to endure it whether the person who's doing it is in unit or not, or et cetera. So it's not inappropriate to have it so that if one party is out of unit, then it would still apply, because it's not about like the CBA can only ever apply to if every single person involved is in unit. A ton of these protections are a protection against mistreatment by UF.
Okay, so
So it's UF.
But it's different to say harassment versus what's going to happen to the person who harassed you is different than. I agree, like, yeah, you
Yeah.
can, but I don't see like how the language I don't see anything in here that you've listed out describing harassment, how that's not already covered by any of our existing regulations or policies. Like, there's nothing that you've included in here that
So it
All
doesn't
this-
contradict
all
your
this,
existing
well,
regulations.
but he's talking about the definitions of harassment still, and I'm saying that's already all covered by the law. Patrick's talking about the processes, and the processes are different than the protections against harassment. So you have you're protected against harassment. We don't want anybody to be harassed. Okay, and then, but if you are, this is the process that you go through, and that's different. That does depend upon what employment group you're in potentially.
Okay, can we move on to the next, provision?
Sure. Where do you wanna move down to?
I guess we're at 13.4 now, right? Because we just talked about processes.
Yeah.
So we're at line 352.
Yeah.
354. All right, I think that we've gone back and forth on this one before. I thought we were relatively good on this one. You know, 1 talks about other employees, 2 contemplates undergrads, and then 3 talks about pre-existing relationships. I mean, I don't think we changed any of this.
Yeah, I guess your Christian starts on line 378, where we redefine the purpose of employee, which employees defined elsewhere in the contract as only a member under the bargaining unit. That's why we have this extra definition, because these clauses refer to employees in general. And if employees don't cover the other employees that work for the university, what's the point of having the word employee there?
I gotcha, okay.
Right,
Hang on, let me.
that's what that was there for.
Let
So you
me
didn't have to
make a note on that. Okay, so down to, the next sort of I think there was a bunch of, whatchamacallit. Yeah, the headings I think got inadvertently deleted, so I'm gonna go down to, I guess 381.
Yeah.
We don't think this needs to be stated. 384, we're not interested in funding a pilot program about this. This is to establish a fund, the way you've laid out here. We're not interested in that. That'll all be, and as part of the resolution of whatever the conflict, grievance, or complaint is, we're not gonna make a predetermination on that.
What do you mean by that?
What do you mean?
Well, this whole committee, or the whole funding pilot program contemplates the fact that if somebody is in this situation, this is exactly how we're gonna behave in it, like, this is what we're gonna do. Well, we would like the complaint and the facts of the case to dictate what we're gonna do. We're not gonna agree in advance that this is what we're gonna do.
Well, no, this is just when GAs, are transitioning out of these unhealthy relationships and, abusive, discriminatory, and harassment.
Right.
And it's just extra funding to help them with that transition. It doesn't put in onus that say, as soon as someone says they're in a position, you have to provide them funding. It's up to these groups.
I guess what I'm saying is we already feel we have an obligation. If we feel we have an obligation to help resolve one of these issues, then we're gonna work with that situation based on what's going on with that person to resolve the issue. We're not interested in identifying a specific funding to deal with it. If that comes up in the course of that case, then so be it, but we're not gonna pre-decide that that's what we're gonna do. Because it almost implies in line 401 that there doesn't even need to be a complaint.
Yeah, but it's not immediately given. It's up to a committee that has representatives from the university.
So it seems to create a situation in which someone is in an uncomfortable situation. They've made no complaints whatsoever. There's been no discussion. HR is not notified. There's been no complaint. And the person sends a memo to this committee that says, I'm in this terrible situation. And then rather it being handled by the people who should be investigating the situation, whether it be the Title IX office or someone else, we're instead gonna just give that information to a committee to make this determination apart and away from a complaint.
Okay, so if your issue is the timing on when doing this, then you could have added that instead of crossing the entire thing, right? If the issue is that, and like how this committee would decide how to do this transition of funding, then that could have been written.
What I'm saying is it would naturally happen at the conclusion and resolution of a complaint. It doesn't need to be given out to this other new body or committee.
Is transitional funding given to people with these complaints to get out of these relationships?
I don't know if it's ever been called that. I mean, have we moved people around to resolve complaints? I mean, I haven't dealt with a case like that, but I'm sure they've existed. I mean, have we moved people around I haven't received any complaints or dealt with any cases like that. Yeah, we moved them.
Have there been cases where someone has experienced like sexual harassment or like a toxic work environment? And they had to like quit their program, because there were no other
So
options?
not a sexual harassment case, but when we have people that don't get along, I mean, just in a general sense, I mean, forget any specific harassment complaint, but we have people that just are not a good fit. Do we support people moving to other programs or changing PIs? Yeah, that happens a lot. Is there a specific committee that hears into that case to decide whether or not that happens? No.
I just want to say, like, when we're talking just now, it feels like we're engaging with what was written. And you're saying like line 401 seems to imply this, that's a problem for us. We prefer like this type of thing. And like, that's what we want to see when we put these proposals, not, and we did this with the last one too. There was, I don't remember exactly, we would have to check the notes, but you had a specific concern about like specific wording. And a reason why you wouldn't choose that wording. Would you be willing to engage with our proposal at that level on paper, not just in discussion, but striking everything out of the paper?
So I'm gonna answer that as diplomatically as I can. And that is, I believe we are fundamentally in different positions with respect to what should and shouldn't be in here on the previous topic. And I'm not interested in getting into the granular detail. I've attempted to explain it multiple times. None of the explanations seem to be good enough. And I appreciate that. Your position is widely different. I'm not sure that continuing to go through all of the stuff that we crossed out at that level of intensity is gonna either change our mind or yours. It's just not. It would be different, Jacob. It would be different if there weren't various other mechanisms in place. And I appreciate, I have heard you say, and I appreciate that you say there's nothing that prevents us from gaining additional protections. I'm not discounting that. I have heard you loud and clear, and I'm not even disagreeing with your point. What I'm saying is, these are not things that are occurring that are not already governed in a very specific fashion by a whole host of other things that exist to protect and prevent this type of behavior. And so on this does not have that sort of specific level of interest and nuanced specificity. This is something else entirely. So I feel like we can talk about this one in a more specific way. That's the best way I can try to sort of explain why I'm responding to this provision differently than the entire battery of associated provisions that we just said no.
Thank you for answering my question.
So you said that the university is interested and has previously provided like funds and like help, like actual material help for people that have experienced sexual harassment to be moved outside of those toxic.
I said harassment of people that don't get along. I have not been involved in any cases of people being moved for sexual harassment. I'm not aware of any of those myself. I'm talking about when people didn't get along, but otherwise we felt they could have been productive, that we helped facilitate them maybe moving to a different PI or moving to a different program. That happens a lot, and it happens a lot of times without us even knowing it. I mean, a lot of those cases we're not even involved in. I'm sure it happens. It may have happened 5 times this week and nobody was the wiser because they're like, you know, this isn't really working out. This person has a lot to offer. You know, it's just not going to work. And so I'm going to move and transition. I mean,
on the sexual harassment front, that is tended to be handled by our Title IX office. And usually it's offered through health supportive measures. So, you know, what can we do to the person when somebody comes and files a complaint and we say, what can we do to support you in this process? Can we move you here? Can we do that? Can we, you know, that's usually handled through, and that's all regulated by Title IX. That's typically handled through that process. And they have some leeway to kind of determine if there was a Title IX, there was a finding through Title IX and it went through the investigation and there was a hearing and all that, there is some leeway to determine, you know, what the most appropriate remedy would be given the facts of the case. But so Patrick probably can't speak to that because he's not our Title IX coordinator, you know, but like our Title IX and those processes are all confident. But that does happen with regularity if somebody files a complaint, and then kind of depends on the facts of the case, what the circumstances are.
I guess like, would you be willing to have something in the CBA that does codify that such that if somebody goes through sexual harassment or is otherwise in a toxic work environment, and I'm not saying just like, oh, they don't get along, like I'm saying like, this is like actual, some type of harassment or discrimination that is happening, that is hurting the GA, to codify something in the contract that says that UF will provide like actual material help, like moving them to a different PI or putting them in a different assignment so that they don't have to make the decision of enduring that harassment or just like quitting their job.
So I don't have it in front of me, and as Olivia said, I'm not the expert on the Title IX stuff, but the entire component of the supportive measure part of that, why don't I get that and send it to you all to review, because it will help contextualize the request a little bit.
Mhm.
And then if you would be willing to sort of look through that in terms of what we already have in place, and then maybe it'll help when we come back and talk about it again, maybe have sort of a better understanding of kind of how we view it. And to Olivia's point, yeah, I'm not gonna know any of the specifics about cases. But it's in our mutual, I mean, the university clearly has a mutual interest in helping resolve the situations, and we have obligations to provide those measures based on the policy. But I will send that to you all, and then if we can maybe have that conversation again in sort of in that context. Again, from the perspective of this is what's in place, what is it over and above that you feel, you know, that you would like or need?
Yeah, I mean, I think actually it would be helpful if you could, put together that for other parts of the article as well. I mean, like what you feel that, what you think we should look at in terms of trying to make sure, we're all on the same page with federal and state law, university regulation and policy. And then we can also say with certainty, like, well, this is what we want that's different from those things. This is what we want that's like in line with those things. Because, yeah, I mean, I think that's the only way to go down a constructive path here. Because if that's really like the hang up, in terms of, what the biggest issue is. And I think we would like to address that, like whatever your concerns are. Yeah, so that would be helpful.
All right, we'll talk about some stuff that maybe we can bring and share with you all about that.
Okay.
All right.
Bathrooms?
Yeah, starting on 423, we're going to switch on the next page.
423. Yeah, we've already sort of shared with you the fact that we believe that, managing our facilities is gonna be a management, right? That we're not gonna bargain.
It's not, what part of this proposal infringes on management, right?
We have to set up our facilities.
No,
Yeah,
we're
yes,
just saying
we
that.
absolutely do.
No, actually, we're just saying that an employee has to be placed near one of those facilities. How you set up your facilities is up to you. That's a management right, and we accept that. Nothing in our provision here contradicts that. All it just says is that the employee has to be placed next to one of those facilities. And that's what reasonable access, huh?
Yeah.
Can I also ask why UF doesn't want to post where gender neutral bathrooms are in the website?
They're already doing that.
Yeah, it's just codifying a process they're already following that we appreciate and we want to keep happening.
Yeah.
That's the intent behind that. This is line 435.
Yeah, we're just not interested in putting in the contract. We don't want to bargain that with you. We don't have to bargain it with you. We're not interested in bargaining with you.
Just be that.
Yeah, it's a management, right? We're gonna reserve that as a. We're gonna govern our facilities in terms of the way we build our buildings and identify our buildings in the way that is our responsibility, and therefore we're gonna do it. And we'll if you have proposals, we will listen to them, but we're not interested in bargaining this.
Do your websites include where accessible bathrooms are?
Yeah.
I don't know if they do today right now.
They do.
Honestly,
And then we're also able to manage our websites if we want.
Yeah.
No, that's fine, but, the requirement of reasonable access to a bathroom is not a management practice. And that's what the main thrust of this proposal is.
Standard, is that a legal, I'm not sure if that is a legal standard, reasonable access to a bathroom, is it a capitalized legal standard, or is that just a phrase?
There are OSHA standards about what constitutes, I don't know if reasonable access is the exact term that they use,
I
but
believe
there,
that
there are,
It's
there are
taken from-
federal.
It's taken from OSHA?
Huh?
Yeah.
Take it
I
from
Well,
think
one of the, no, this, I don't know if the exact language is taken.
The exact thing is
But,
that the term prompt access and how they define
Uh-huh.
it.
Yeah, if you can provide us the building code language that requires.
Yeah, the one that you drew from, like, that'd be
Sure.
helpful, if
Okay.
you wanna send that to us. All right, so down on 436, Committee on Understanding and Prevention of Discrimination and Harassment. Yeah, we're not interested in creating in.
Sorry, where are we right now?
437.
Okay.
We're not gonna put an opinion position one way or another on this in the contract. And we're not interested in creating this committee. What we will remain open to, and we are interested in, is any cases that are like this, that you become aware of. We'd like you to bring them to our attention promptly, and we will deal with them. So if there is in fact this escalating incidents among the employees of these problems, we would like you to bring them to our attention, because I'm not aware of any since I've worked here in terms of things that have been brought to our attention, so.
And this is from the police reports that the UPD releases each year about incidents on campus that are. And they do determine this, escalating incidents of violence against women and crimes.
Which UPD report is it?
And they do an annual report of like, crime statistics. I can dig that up and try to send it to you as well.
That's fine,
But,
I can.
and they have it for several years in the same document, so it's pretty easy to read. And so the intent here is, understanding that it's happening across campus and across your campuses, trying to understand why that's happening and work to understand and diminish those incidences and why they're happening at the starting point.
So specifically with respect to you as an employment group, however, I guess that's my question.
What do you mean?
Because, is it split out in terms of, again, because this isn't necessarily about the governing of the entire university, just our relationship with you all as employees.
Mhm.
And what I'm saying is I'm not aware of any cases where it's involving you guys as employees, which would dictate us putting something in here in your employment contract about specifically dealing with the problem for you all as employees. That's my question.
Well, the information is for UF, the information Austin's referencing is for all of UF campus. Well, we work at UF campus, so I mean, that's where,
Got it.
that's where that information comes. Now, I'm guessing what you're meaning, like specific information about GAs, like kind of like that police information, but for our group specifically, is that what you were asking?
I guess what I'm saying is if we're going to have specifically a committee about you all, it sounds like, and I'm not disagreeing with the statistics or whatever research you did, because I haven't looked at it, but I'm gonna take you at your word that you found it and you found it compelling. I'm not sure why the way that we would address that, if it's given in broad terms, would be to have a committee just with you all. It would seem like that would be something that would be of more value to a broader group of people, and it wouldn't necessarily be something contemplated in your employment contract, but it might be an initiative that is taken on a larger scale. I guess that's all I'm trying to say.
Okay, yeah, I understand that.
If you were to take it on a larger scale, inspired by what we as organized employees have like proposed, then we wouldn't feel the need to propose something specific.
Say that again?
I think if you were to take it on a larger scale, inspired by what we as organized employees have proposed, actions you take, then we wouldn't need to propose something more specific if you are already taking it on a wider scale. But the fact of the matter is, this is under discussion because a group of your organized employees see the need for it and are proposing things.
Okay. And then I guess that's different than the next committee you've proposed, which is the Committee on Understanding and Prevention of Discrimination and Harassment.
That's the same committee.
Oh, it's not a different one?
It's the same right now. That's just
Okay.
putting a lifetime on the end of
Gotcha.
it.
The VAWA wasn't a committee, that's just the violence against women.
Okay.
Yeah, the actual committee, yeah.
Got it. So I guess then we're down to 13.5.
Yeah.
Which I don't believe we made changes to. 13.6 you'll see is highlighted. And the reason it's highlighted is because we aren't opposed to the language. We're just not sure that this is the place it should go. I mean, I don't think we have any, like I said, I think we're okay with it, but again, just make a note that maybe it can fit somewhere else and maybe this is the best place.
Well,
but-
just the highlighted part, not
Not the whole
crossed out.
sentence, yeah.
Just the 13.6 part.
Do you have any ideas of where you think that might go?
We haven't really thought that far ahead, quite frankly.
Right, well, but 13.6, but excluding that last part you crossed out.
Correct.
This be clear.
I mean, I just like, we already do, I just,
Yeah.
like, we have, this is a restatement of HIPAA and FERPA, so
Right.
for the student anyway, employee, but.
Right.
Yeah, and then we have 477 through 480. On gender identity.
Yeah, we just have no interest in this particular provision. We don't think it needs to be contemplated in the employment contract. And we're not interested in putting it in.
Same thing for the next part.
Yeah, we think that's all connected. I know it looks like it's tabbed differently, but I believe that those are all connected.
Yeah, well, 100% sure.
Yeah, so when it gets to 485, so this is actually a new federal law that we fully intend on complying with. So we don't feel it needs to be in the CBA.
It's a new fact. Do you happen to know? I don't know.
Pregnant Workers Fairness Act
There you go.
Okay. Yeah, I know.
and the Pump Act.
13.7, we didn't make any changes to. 13.8 is already agreed upon language. And then we're not interested in a separate, like, severability component inside here.
I think I read them all, so. Yeah, that one. Second part, well, definitely.
And with regard to lines 508,
I think that should be covered.
with regard to sort of the explanation that's given in 508, I'm not sure, quite frankly, that. So severability is more about taking stuff out. Typically, that's what it's used to do. I'm not sure how it would be possible for us to add a class to our general policies and then just exclude you all from it. Like, I guess it would be possible if we wrote the policy in an extremely strange way. But if kind of what we we're talking about before, if a new class was recognized by federal law, and then we said, well, we're gonna go ahead and put it in our policy, but we're not gonna extend that protection to just this one employee group, which is almost what I feel that provision contemplates.
No, it's to do the opposite, right?
Yeah. It's whenever someone at the university adds an additional category or categories of protected classes, they're added and under recognition under this agreement.
Right, and what I'm saying is that if we were to add a class to our umbrella policy, I'm not sure how we could add it to our umbrella policy, but then say, but we're not gonna extend the protection as part of our umbrella policy just to this group of employees.
No, we're
But it's
saying that we would
Yeah,
change
it
the
would
CBA
automatically
to
be that.
reflect that change.
But that's not how
Right, no,
all
that's what-
regulations work. If it's a regulation that is separate from this class, it's not required by state or federal law, the university added it, it would not automatically require us to
Like
add it
we
under.
accept it.
Right, you're adding it of your own volition.
Yeah.
And we could change the language in lines 27 and 28 to say, or any other category protected by applicable federal, state law, or university regulation.
But we don't want to do that, because then you could have whatever you want to the regulations that, we might not agree with.
Well,
Right, that gives us the chance of saying if we agree or
Add
not
the
agree.
class, okay.
I mean, we put that in there because you had raised concerns about what happens if the Title IX regulation changes and then there's a conflict with the contract.
Right.
And the whole point of this is so that there's no conflict.
Right.
Right,
That's
but this,
different than what you were just saying.
yeah, this is very narrowly construed just about adding classes to the policy.
Exactly.
Right, so if we add a class to our policy. And it's part of our policy, then what we could do, so now you're talking about combining with articles 27, like 25, 27, 28. If you feel that that would be an abridgment of the contract for us to include that class. You want us to just automatically add it, or you wanna go through the process of having an opportunity to bargain it.
Well, it would be kind of an impact bargaining thing where we would just add that word, and I don't think that there would be like a huge argument from us on that.
Why wouldn't we just say, why wouldn't we just say or UF regulation, and then it covers that, you don't have to go back and impact bargain. To line
Okay,
29.
that's fine, yeah.
Yeah, the hypothetical of you getting additional protection if we change the policy I don't know how that would disadvantage you, like if we add additional classes.
Yeah, we're gonna cover you.
We're
So
gonna
that's
cover
why
you
this-
anyway.
that's
Well,
why
I
we
mean,
have to cover
if
that.
we end up TAing the proposed for articles for like 25, 27, 28 for all that severability and impact, then in that case, if there was a change, like a class added, it would probably go through that process and we would discuss it.
Yeah, I mean, I guess the thing is you would at that point, you would have to bring a grievance that we afforded you a protection that you didn't want for some of your employees, which seems pretty absurd. If we're required to add a class, we're going to protect the class, and I don't think you all would be like, don't you dare, like, that seems very.
Right.
Right,
Okay.
We've heard you say, like, we could address this through line 29, and like, based on just listening to what you're saying, it makes sense. It's the type of thing that I wish you had put in the paper and kind of responded to the substance instead of just said extemporaneously in while we're meeting here.
Well, sometimes we need to have the discussions to understand one another so that we can propose the language. That's why we're here. We're not just sending written proposals back.
Okay, so after this discussion, now you understand better what we're going for and you're.
Yeah, and you can provide a counter proposal and we'll look at that.
Okay, and we would appreciate those references that.
Maybe, let me make sure, I'm gonna go back to where I have the list here.
And we can just talk about our Title IX policy.
Yeah, talking about the
Sorry,
Title IX supportive measures thing, I'll send the link to. That'll be on that. Okay. All right,
Okay, thank you.
all right, thank you.